Welcome to Legal Innovation Spotlight, the podcast that brings you the latest advancements in legal tech and knowledge management. I'm Ted Theodoropoulos, and I connect with the industry's brightest minds to provide you with valuable insights and actionable takeaways. So sit back, relax, and let's dive in. Brian, Rich, how are we doing this afternoon?
Fantastic, Ted. How are you?
Doing great. I appreciate you guys getting together on relatively short notice. We just had a conversation last week about the Stanford paper, and so many developments happened just even last week. You know, we had Harvey AI release some benchmarking, and so there's a lot to talk about. But before we get into that conversation, why don't we just do quick intros? Rich, who you are, what you do, where you do it.
I am the Director of Applied AI at Reed Smith, where I have the honor of working with Brian, who can introduce himself.
Hi, I'm Brian Blaho. I'm the Global Director of Library and Research Services at Reed Smith.
Those were very concise introductions. I like it. Gives us more time to talk about the paper. So, the Stanford paper, I actually saw the first inkling of this early in the year. I think there's been a couple of revisions, right? I think they had a initial release sometime in early spring, and then there were some things pointed out about the tooling that was used to do the analysis. They went back, made some adjustments, and now we have a 38-page paper, really 24 pages, but there with some appendix information. And I don't think a lot of people have actually read the paper, is my guess. I think
that's right.
Yeah, I think they've read the summary, the abstract, and they've read some analysis on it. But you know what? The paper itself is really interesting, and I learned a lot from it, especially not being a lawyer, and understanding some of the intricacies of interpreting law and how challenging that can be for an AI platform. And yeah, I've got all kinds of thoughts and comments about this. But Rich, you were the one who initiated the dialogue around this. Why don't we start with you and talk a little bit about just an overview of what the paper, what the goals were. I think you actually had somebody from the academic world weigh in on the methodology used in the paper. Just give us a quick summary of your perspective on it.
So, look, the paper came out and caused great notice, a lot of commentary, and so a colleague of mine who I collaborate with out at UC Berkeley around Gen AI, and he has a background in the legal research space. He said he wanted to talk about it, so we had a conversation. We included Brian. We made the effort to actually read the paper. You get these summaries, and one of the things that we always do when we look at the stuff at Berkeley is we throw out the abstract. Well, we don't throw out the abstract, but we read the paper. We don't, you glance at the summary, you read the paper. The paper at a high level, right, is this research group at Stanford wants to look at the efficacy of the big legal research tools, primarily from Thomson Reuters and Lexis. They came, they looked, they saw, they were unimpressed, and said, the stuff doesn't work as well as claimed. They do their study, they issue their paper, and it grades out pretty harshly. A lot of people reacted in a pretty dramatic fashion. The vendors took issue, and there was a lot of commentary. What was interesting to me is when you go in and you read the paper, it lays out in a transparent fashion exactly what they did, how they defined accuracy or hallucination, the process they went through, how they scored things, and even got into details of problems with RAG solutions. And it's actually a nice discussion. And my reaction after reading the paper and talking to Mark Butler from Berkeley and Brian was, we're not sure if the takeaways and all of the kind of consternation really gives the paper and the work its due. And so that started this conversation. So I think, at the highest level, people have criticized the work in a number of ways. You used questions with, misleading, gave misleading questions. And we don't like the way you graded and things like that. Well, in the paper, they say we have a section of implausible premises or misleading premises, whatever the label was. And it's, X%, and here's how the models did. And that was, quite intentional. They said, here's how we're going to grade. And you can disagree with those things, but at least they were transparent. Yeah. So I thought it was worth a conversation.
I think so too. And Brian, what was your take on reading the paper and how the conclusions in that related to your experience with some of the tools out there?
I've read the paper more than once now, and in the early days of this being pitched to law firms, of it really making a splash after ChatGPT came on the scene, we were all trying to get up to speed on exactly what this technology was and how to approach it. And that's not just on the law firm side. That also includes the sales teams that we were working with, who were bringing it to us and offering it to us at market, who were not the developers of this technology, but we're also trying to learn how to engage these tools in the best way. And so in this frenzy, we leapt in really with both feet and tried everything we could get our hands on, anything we could get a trial for. And what strikes me about the paper is how closely aligned our initial reaction to these tools was with the conclusions that were drawn. Not about any specific tool, but about large language models conducting legal research writ large, right? This tool did a little better here, that tool did a little bit better there. It certainly doesn't take into account everything that's currently on the market, all of the options that are available for a law firm to invest in. So there's a lot of room for growth, but in terms of, we were getting responses from our attorneys saying that it was wrong, that something they got back was wrong. And when we would dig into those responses, the classification, we had to come up with our own classification system about what wrong meant. Did it just not meet expectations? Did it not behave in such a way that the lawyer would have trained their associate to, right? Did it come to a different conclusion, but behave exactly the way a large language model is supposed to behave? Did it provide an answer that it may even be true, but was not supported by the documentation from the library of sources that it said it had access to? Did it make something up out of whole cloth? All of those were different kinds of, errors, so to speak. Maybe not errors. But we didn't have language. The only word we had was hallucination, which didn't seem to fit all of them. So this started to put some framework around the way we might think about the way large language models respond, especially in something that's such a big swing as legal research, which requires a great deal of analysis and understanding outside of just the core documents that you're going to cite.
Yeah, and I mentioned to you guys last time we spoke about this, which is I have a Six Sigma background, and they have the concept of DPMO, defects per million opportunities. And if you're going to operate at a Six Sigma capacity, you get 3.4 defects per million opportunities. Now, what does that mean? Well, that means that any time there's an opportunity for an error, that's an at-bat, right? So you can have, let's say, in a manufacturing context, this cell phone. Well, you could put the screen on wrong. You could leave a button off. Each one of those represents a potential defect. At which point does the phone itself become defective? And I think that's kind of the same concept or construct that the paper tried to create, which is, hey, this is when a this is when an output becomes defective, and it listed out very clearly what the criteria. And like you mentioned, it could have been something that was ungrounded, or that was factually wrong, or just a refusal to answer, which I thought was kind of funny. But talking through, Rich, like, I know there's been a lot of misconceptions and criticisms about the study, but specifically, and I think that my read on this, and I've read lots of academic papers over the years. This was a particularly easy read. Usually they're a little more difficult. This was an easy read. There were a couple things that surprised me about it. One was how specific they were talking about the vendors. That was interesting. Maybe this happens in the legal world all the time, but in most of the scientific papers that I've read, they're a little more broad brushstrokes. And they had the conclusions had a fine point on them. I mean, they didn't mince any words. But what is your take on the misconceptions and criticisms about the study itself?
So, I mean, a couple things. The paper, as these papers go, was a relatively easy read. Not a lot of math. Not it wasn't shot through with particularly challenging jargon. I think that what they were looking at, right, was a review of a small number of the really big vendors. Now, they could have done it, I suppose, without reference to the vendors' numbers and just sort of published their results. And I think a lot of that is, around kind of a sort of fit and finish. I mean, if you want to criticize the study and say, look, it comes across as though that they had a point to prove, or there was a, kind of a bias, that it wasn't a neutral call, or you want to look at the summary and say that was reckless. Okay. I'm not even commenting on that. I'm just looking at the work, kind of saying, did they tell me what they did? Did they explain what they did? Could I read it and understand it so we can have a conversation? And that's really all I'm saying, right? I'm not saying it's really anything other than that. And so, if people want to say, all right, you counted as a hallucination or an inaccuracy, being a little too chatty. You said 15 things, and of those 15, 13 were right, 2, not so great. So you get 0 score for that. Well, that seems a bit harsh. Okay, then let's regrade based on that. I don't care so much about the numbers. I like the fact that we can have a conversation around the standards that we use to grade. I would like to see far more of the questions and answers that made everything up. I'm thirsty for that. I guess my reaction is to just kind of throw up our hands and go, oh, this is just horrible and biased, and walk away. I struggle with that. And when the vendors come back, then say, all right. When a vendor comes and says, here are the numbers we got, I want to know how you got those numbers. I want the same level of transparency. I want to say, here's what we define. Here are the things we will tolerate. And it may turn out, look, if you apply the vendor's standards or some other competing standards to the same tests, you get different numbers. Terrific. I just want the conversation.
Yeah, that makes sense. And then, Brian, were there any lessons learned for you, for future AI research evaluations? Did you walk away with anything from that?
Well, the first was not to necessarily draw conclusions from a catchy headline. There were really a lot of clickbaity headlines about this. when it first came out, and I read all of those articles. I was deeply invested in knowing what was being said about it. It's not necessarily that anything that was being said was right or wrong. It's that it didn't give you the whole picture. Like going back to the source here and truly understanding a little bit more about the way the study was conducted gave us a lot more insight into just the raw conclusions, which might be slightly different from other studies where you can just walk away with the conclusions that came out and say that's the whole picture. But in this instance, it's still so muddled about exactly how we're going to utilize this kind of technology, not just in legal research, but more broadly across our business in all kinds of different ways. We know that we will be engaging it everywhere, but exactly what impact that will make is still a little bit of an open question. And so kicking off the discussion about this doesn't necessarily mean we've come to the final answer. And that would be what I would walk away from.
That's a great point. At least this was a starting point. Perfect, imperfect, you make your own assessment, but it did seem to be transparent. And again, you can take issue with the scoring mechanism, but they laid their cards on the table, and I think it's a starting point. And I mean, to your point, Brian, there were some pretty strong reactions about this, and I think people drew conclusions by reading some of the articles. I don't know how many people actually read the actual paper, and it's kind of hard to have an informed opinion on this if you haven't taken the time. Rich, I know you talked to a few people about this. Like how many people have taken the time to really dig in and understand the full text?
I can't. I say, have you read the paper? There's always a bit of a pregnant pause. They don't go like if you say to me, I go, yeah, I read the paper. It's like, did you read? I'm like, wait, did you mean the summary that came out from the? I'm like, no, did you read the paper? Like all 38 pages. Like, what did you think of the section where they talk about the strengths and weaknesses of RAG? And there's like, wait, there was something in there about that? I'm like, yeah, there's a whole section, and it's really pretty darn good.
It is good.
It's and by the way, that's not to say that retrieval-augmented generation is the be-all and the end-all. It's not. I've built those systems. You can build a simple RAG system in about 10 minutes, naive RAG. But it's all the other stuff you put around it. And so it's just, and again, I'm not saying that, that the paper is perfect or even wonderful, but it's useful. And it is a well-structured bit of work. That's not to say that it can't be better and that we don't want more. But as a means of starting to say, here's a framework for defining what we mean by accuracy.
Yeah.
Here are ways to talk about these things. Here are ways to carve out the tasks and the data sets. Okay, if you don't think it's fair game to put in a series of questions that have, flawed premises, great. By the way, if you look in the paper, you'll see they scored for each category. You could back those things out. So, it's there. And like seeing the community circle around all of this, get past the initial sort of friction and say, now as a community, let's talk about what data are we going to use? How are we going to benchmark? How are we going to talk? Let's come together. I think that's fantastic. That's the byproduct. That's what I look at, not the headlines.
Yeah. What popped up to me is, not being a lawyer is section 6.2, which is hallucinations can be insidious. And this is RAG that they're talking about, right? Not just the generic GPT-4 model. And it rattles off all of the challenges, that the systems do not seem capable of consistently making out the holding of a case. So it misunderstands holdings. It can't effectively distinguish between legal actors. It does not respect the order of authority. It blatantly fabricates information. It's got a whole inventory of, and the first thing that popped in my mind is, wait, but this is better than the system that scored in the 90th percentile on the bar. And, I realize it's different, but then, you and I exchanged a couple emails about this. I'm like, wow, okay, I know that, multiple choice, but that's a really, the picture they're painting here is, I think you had some comments on that, Rich.
Yeah. Well, I mean, a couple things. First of all, some of those attributes are endemic to the LLMs themselves. Some of those things that are observed are actually issues with a structure of at least a RAG or the RAG or any RAG system, because part of a RAG system is you bust up information into components and you retrieve the most relevant handful of components and then reason from there. So there's a lot to how you cook with these things. The bits about not understanding, sort of jurisdictions and how courts stack and things like that. Well, that's because you're expecting reasoning, and the systems don't reason. And one of the things that I get a little on edge about when I read these papers is when they start sort of anthropomorphizing the systems. It reasons, it thinks, it understands. It's like, no, it predicts the next token. In the NLP community, say it is a stochastic parrot. It just uses statistics and pushes out words and doesn't understand anything. The bar exam is different, right? That's common legal knowledge, core concepts. Largely, you give multiple choices. There's no legal research component to that. You ask questions, you give answers based on information that's floating out in the universe. You have multiple choice. Model says, what's the most probable answer? Bang, goes. That's a far easier task than a legal research task. Yeah, there's legal writing on the bar exam too. GPT-4 scores much lower on that. Still passes, I believe. But that's not legal research. I think one of the things that all of this causes me to realize is, and Brian, I'm curious about, sort of your reaction. I mean, when we started all this, we thought, hey, legal research was going to be an easier use case. And the more I think about it, the more I realize, it's harder. And in order to do it well, you need to think like a lawyer and understand these legal concepts to do the stuff effectively. And the models are not equipped to do that. And it'll be on the vendors who build on top of the models to add the other workflows and the agentic systems and the other things to get us there. It is, as we say, never as bad as it is today. It's going to get better every single day. And we see that arc.
Yeah, it's a really good point. Legal research is complex for a number of reasons. It's built on, which is certainly referenced in the paper, it's built on the common law system. But if you think about the way that you approach a legal research question, or really any question, even if you were just going to Google, you get back, like in current technology, pre-generative AI technology, you ask a question in one of these systems, brings back a list of results. You've used probably Boolean or natural language to generate that question, which is really refining it down to very specific concepts, which we're all pretty good at now because we've engaged in that so often. The results that you get back can contain a variety of opinions and a variety of different responses to that question. It's not laser focused on your intent. It's related in some way to what you have asked. So in order to be a good legal researcher, you need to not only understand the answer, which is what these sort of memo generating systems are trying to do for you. They're trying to get you to an answer, like they generate a few paragraphs and some citations that answer your question. But you need to also understand cases that are related that are not included in the answer to that question, because it's very nuance driven legal research. You have to legal research. The answers are always yes, except, or no, unless, right? And it's that except and unless part that complicates it and makes it so you need to be able to respond to that when your opponent is relying on a different set of cases to get a different result. So you have to be able to tunnel through sort of the question in a way that benefits your client. And it's more in that way, it's more complex. It requires more analysis. And that's exactly what the LLMs can't yet do, is the analysis part.
Can't
Not
yet? Yeah, right. Okay, but are they really even the right tool to get us there, Rich?
Well, I mean, again, it's the advances today. No, in isolation, no. But none of these systems are using an LLM in isolation. And
Mm-hmm.
the better, the solutions to the more challenging problems usually involved a collection of techniques. And there's no way we could begin to, well, we could certainly speculate about where the models are going, and the advances that we've seen in a short period of time are just astonishing. And not to sit there and say, well, within 2, 3, 4 years we won't see dramatic changes in the ability to work with this information and capture other things and embed other notions. Oh gosh, I mean, I think the sort of the sky's the limit. Right now, I mean, I fully expect the vendors to do far better than the unadorned model, because they're pouring their time and effort into those other things. And look, there's great art. The things that the leading vendors are doing, and the energy and the effort into building these systems, including layering on additional passes of error checking, and it's we are still early on. I think that what's being achieved right now is pretty darn amazing. But I think you have to look at it with that right lens, and don't take any criticism and sort of get defensive about it. There's work to be done. I do worry a little bit about the anyone who says, well, we're using RAG, therefore there are no hallucinations. It's like, wrong. And by the way, again, how do you define what that hallucination is? Because as soon as you say, well, we're using RAG, therefore we can cite all our sources. But if I say a hallucination is a mistake, oh my gosh, there are 1,000 ways a RAG system can fail.
Yeah.
There's a huge emphasis on the retrieval part of RAG. Are you getting the right stuff?
Well,
I just want to emphasize what Rich is saying. I am very bullish on this technology. I think what we're seeing already is absolutely incredible. I do not want to give the impression that it's broken or it doesn't work. It does. When you give it the right questions, and when you're asking the same questions that the developers considered you might, it's when you start to challenge it. Those questions that they specifically include that are slightly misleading are very directly included because they will give the model a challenge, and then you want to see how it responds. And that's a really important thing to know. No human input is going to be completely error-free either, right? So will it be able to pick up on that and help you navigate that, even if you've not done the best job of prompting it or engaging it?
But I think there's another part there, Brian, which is that the models themselves are built to respond.
Yeah.
I'm not talking about anything a vendor's done on top. The models are built to generate responses. Long before we had the chat models, the models were called completion models. You begin a sentence or a phrase, and then you stop, and the model fills in the next few words, right? If you go row, 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 GPT-2, which we use in school, you go row, row, row your boat. I would hope it will complete with gently down the stream. Merrily, So the idea, and again, the models are built to respond. So sometimes you'll see ChatGPT, GPT-4, any of those, sometimes they'll push back. I love it when that happens. But oftentimes It won't. And so knowing that's not a thing that a vendor did. That is a tendency of the underlying technology. And you either build around it or you don't. So one of my favorite examples recently was, this was with, I can't remember if it was an OpenAI model or a Claude model. It was during the Democratic National Convention in Chicago. And I said, who spoke on, August 21st? And the model coughed up an amazing answer. And I immediately thought, wait a minute, how is it possible? The model wasn't trained on what happened last night. But the answer seems so darn good. And then I went, wait a minute. No, those people actually aren't at the convention. That was just a really plausible answer. That's all the models are built to do. Now, sometimes with the very same prompt, I got the model coming back and saying, oh, this is after I was trained. Go look elsewhere. And again, this is not about Lexis or TR. This is just the sort of the implausible premise, the thing it can't do. The models are built to respond. And so it is perfectly fair game, as far as I'm concerned, to ask the questions that have an implausible premise, because I want to see how the systems respond.
Yeah.
Yeah. So in between when we last spoke about this, there was some news about Harvey created a benchmarking initiative, and I don't know how much either one of you have had, how much of a chance either one of you have had to read about that. But I don't know, Brian, have you looked into that? Any initial thoughts conceptually about a vendor leading that effort?
Briefly, Rich and I were chatting about this. We were chatting about this over the weekend. I think he has some deeper thoughts on this, so I'm going to kick this to him.
So, look, I love that Harvey and Ted, we talked about it before. We're a Harvey client. We work with them all the time. So I when I say what I'm about to say, I want everyone to know that. But I haven't talked to them about this. So what I loved about it is, Harvey puts out their information. They say, here's our benchmarking project. Their summary paper talks a little bit about what they were aspiring to do, which I thought was kind of an interesting structure. I love the fact that people, some people in the community, including, Richard with artificial lawyer, says, oh, this is positive work. Let's join ranks and keep working on this. So I read the paper, and in the paper there is a link, or not the paper, the thing they released. There's a link to a GitHub repo, and I thought, oh, fantastic! When I go to a GitHub repository, I expect code and data and detail and all those good things. And I go to the repository, and there's really not that much there. It's really thin. And there's a comment that says, hey, if you want to get more information, go ask us. And I posted on LinkedIn, in reply to the Harvey post saying, yeah, get us the data. So I love the idea of a vendor, any vendor, helping to advance the ball, if by what they do is they share their methodology so that others can understand it, work with it. I want them to share their data so we can have a common reference point. And it's up to the folks at Harvey. I mean, if you read that paper, and some paper, again, it's not really a paper. If they read that posting that just says, we thought about this a little bit, and here's our work, and our stuff scores better than others. Well, that comes across as a little self-serving. And again, I don't care. I really don't. I'm not surprised. I am skeptical of a vendor leading a charge about how things should be benchmarked. But if they want to gather with the community so that we can develop some open standards and coalesce around some open data sets so that everybody can use it and critique it and understand it, then to me, that's the best of open source. So we'll see. It's up to Harvey at this point.
Yeah. And then, there's the Legal Gen I Accuracy Group. I think they're over in the UK. Yep. I think it's fine for a vendor to get things moving. It's not fine for a vendor to lead that effort. It's inappropriate, in my opinion. It's again, getting the ball rolling. I think it's great, but industry, not even academia, in my opinion. I think it needs to be end users that need to drive the bus on figuring out how we measure, right?
Yeah.
Otherwise, there's because at the end of the day, they're the ones paying the bills, right?
Mhm.
Academics aren't. Vendors are the ones selling the solutions. So the actual consumers of the technology, I think that's the most important perspective. And I don't know. I had not heard of the Legal Gen I accuracy group prior to the Harvey announcement. So I don't know how far along they are. Do either one
Yeah,
of
they're
you?
very early on, right? That was, I think that's the same group. That's Richard Truman's,
It is.
and so one of the first things that he posted. So look, Richard and the folks at his organization, I think largely. Or at least as part of a reaction to the Stanford paper, said we need to have a serious conversation around all of this. He and colleagues are, putting together this group, which I think is fantastic. When the Harvey paper came out, Richard posted, "Hey, look, they've started to do a bunch of the work we were already thinking of doing. Let's build from that." And I thought he said that at one of their upcoming meetings that Harvey would participate. So it didn't feel like it was Harvey driving the bus. And if they want to contribute some useful things, great. But then I agree with you. I think it needs to be in the hands of a user, a consumer community, and let's coalesce around some standards to have a great conversation. Um, the nice thing about the vendors is they may have resource they can contribute. They can contribute, thought product
And
kind of
time,
thing, so because this is, none of us are getting paid to do this.
right?
And so, you do it for the benefit of the community writ large. And that's sort of the spirit of all these things. But yeah, I'd be skeptical if it was vendor led.
Yeah. Yeah, and maybe they're just leading the charge. Yeah, it says here John Krask from CMS was the one who set it up, but I don't know, Richard. Maybe.
Yeah, um,
But well, switching gears a little bit. One thing that you mentioned, Rich, that I thought was my biggest takeaway from the paper. It was educational for me and understanding the limitations of RAG. Like, what are conceptually these limitations? How, it sounds like you're familiar with it at a detailed level, building these systems. Like, what were those limitations overstated? Were they aligned with your?
it was one of the nicer. It was, I thought, one of the nicer summaries, certainly outside of the sort of Gen AI community, around this. And look, for those of us who've built systems, they're a lot of fun, right? You can build one of these things really pretty easily, and you can do the toy examples, and you get very, very excited. And then the second you try to do something real with it, they start to disappoint. And then you start to unpack why. And there's when you create one of these systems, one of the first things you do is you slice up the information that goes in. So the example I like to use is, let's say I want to do a RAG system where I want to capture the information in a book, but I got to slice everything up. So I'm going to throw every page into a database. And then when I ask the question, the retriever part says, give me the 5 most relevant pages for that question. You then hand the 5 most relevant pages back to your LLM with the question, and you try to answer it. Well, what if in order to answer it, I need 10 pages? Did I get the right 5 pages? What if the answer I was looking for happened to cross over from page 5 to page 6, but I pulled back page 5 and not page 6? how we find these things has a lot to do with the relationship between the question and an answer. In the simplest form, when you go to one of these vector databases, which is at the heart of the RAG systems, you take your question, and the assumption that often works is that the concepts represented in the answer look a lot like the questions represented in the question. So you start by doing a search on the question in the database to find the things that are the most relevant. Well, if it turns out that the answer bears no resemblance to the question articulated, you're likely not going to get the right stuff. What if your database has things that are somewhat related but not close enough? And then we get into notions of time. I mean, it just goes on and on and on and on. So when you want to do these things for real, you get a toy example really, really quickly, and then they will disappoint. And then you start getting into the art of how do I really build a good RAG system? And that's what the vendors are doing right now. And so actually, I thought that the summary of the RAG systems in the paper and their infirmities was really instructive. Not to say we shouldn't use them. Some people have, it bothered me last year. So if you look at what happened with the Gen AI stuff, we looked at the models. We said, oh, the models aren't current. They can't cite their sources. They hallucinate. They don't know my stuff because it's private. All is lost. All is lost. And then people go, wait, we can have the side database with the stuff of information we care about, pull that background, the answers in there, hallucinations drop a lot, not to zero, they drop a lot. We can cite our sources. Oh, it's wonderful. All is well. Well, not so easy. And that's where you build and do more sophisticated things, which is what people are doing. When you hear people say, I've got a RAG system and I couple it with a knowledge graph, and then I do hybrid search where I put all these things. There are these papers now on, sort of growing levels of sophistication of these systems that at their heart have RAG. So to me, it's not enough to say, does RAG solve everything? No. Does RAG alone? Well, it is necessary, but not sufficient. I can't look at a flawed RAG system and say, therefore, it's all garbage. No, you keep going. So
that makes sense.
That's my rant on RAG.
That makes sense. Another question that popped into my head was the Goldman report that 44% of legal tasks can be automated by Gen AI. I really am questioning what assumptions that were made to come up with that number. And I realized that I don't know if that was that got a lot of attention in the space at really senior levels in law firms. I mean, that was thrown on the desk of EC members and said, we have to think about this. And I don't know, Brian, what based on, obviously legal research is a key piece of the puzzle of many, many types of the legal matter process. Does that number still sound reasonable? 44%, or, was this a little bit of a sensationalism?
It's hard to say. It's definitely going to be transformative in a lot of ways. Quantifying that at this early stage, I think, is difficult for me to comprehend. And I don't know exactly what analysis Goldman went through to get to that particular figure. I look at legal research itself, like it's only one aspect of practicing law. And there are certainly tasks that we do manually that I anticipate can be better automated now that we are moving into a world where generative AI exists. Like curating a newsletter, for example. We get feeds of news, on a particular company. And there are people that have to go through and say yes, yes, no to all of the articles that we get about which ones to include, because which ones are most targeted for a particular task or a particular practice area, right? It depends on who who has requested this custom newsletter from us and exactly what it is they want to accomplish with it. So generative AI can help us get much better, potentially get much better results, so that we have to either spend far less time reading through and curating which ones we're going to pass on, or no time at all, right? Where we are able to, we get to a point where we're able to trust that we've set it up properly so that it will be sending reasonable results, right? The option that we have now, if we don't curate it, is to just allow these feeds through, and then they very quickly become noise, because while there's a few good pieces of information contained within the search results, there's a lot more that aren't, right? That are not relevant. And that just happens all the time. So I can think of tasks that will definitely be improved, but I don't know that that will necessarily relate to doing less work. It is very likely to lead to a world in which we're setting up far more of these, right? And so managing more of a program, as opposed to, like finding those who are willing to take as much resource as it takes right now to manually conduct this. Right. So it's hard to say. I think it's kind of it's too early to tell from my perspective.
But I mean, you can't go from, I don't know how to go from some findings that suggest legal research is harder than perhaps we all thought, to statements about what percentage of work, sort of Gen AI might take off the table. Tad mentioned this to you, and some of my examples this morning. Look, I was a transaction person, a deal guy. I spent 25 years, zero time doing legal research, not because I had others doing it for me. It's just it goes back to what were the tasks.
Yeah.
So when I look at the Goldman number, I want to unpack it and say, in order to get to that number, here are the assumptions. Here's what we mean. Because there are so many tasks that lawyers do. And that's actually, if you go look at the Harvey piece, they start out by saying, we want to try to figure out how lawyers are spending their time. And again, I have not reviewed it carefully. I don't know if I maybe I'll agree, maybe I won't, but we need some conversations around that and then get into it. It's just otherwise it's just too amorphous. It's just too abstract.
Yeah. Well, it's going to be interesting. We are quickly running out of time. This is a topic we could explore for many hours. Unfortunately, we don't have that time available, but it's going to be interesting to see what happens next. You've got the Harvey benchmarking initiative. You got the Legal Gen AI Accuracy Group that's overseas. Maybe something happens here in the U.S. Who leads it? Who's involved? All that sort of stuff. It's only time will tell. But maybe by the time this episode airs, those questions will be answered. That's how fast things seem to be moving right now. So I really appreciate both you guys taking time out of your day to chat about this. It's been a lot of fun. And I'm sure there will be many more developments in the coming weeks and months, and maybe we'll put our heads together and have another conversation down the road.
Absolutely. But when something comes out, read the paper.
It's good advice. That's good advice. All right, gentlemen, thanks for joining today. I really appreciate it.
Thanks, Ted.
All right.
Thank you, Ted.
Take care. Thanks for listening to Legal Innovation Spotlight. If you found value in this chat, hit the subscribe button to be notified when we release new episodes. We'd also really appreciate it if you could take a moment to rate us and leave us a review wherever you're listening right now. Your feedback helps us provide you with top-notch content. Want to dive deeper into the world of legal innovation? Connect with us online at getinfo-.com, where you'll find additional resources and articles. You can also follow us on social media at getinfo- to stay updated on the latest news and insights in the field of legal tech and knowledge management. Once again, thank you for joining us today on Legal Innovation Spotlight, a fireside chat series hosted by InfoDash.